We recognize Assemblymember Patterson is present, who is presenting 3 bills today.
Thank you very much, Mr. Chairman, and members, for the opportunity of presenting the 3 bills with a very brief little premise. Whatever your inclination may be with respect to these bills, and whatever your generalized perception might be of circumstances with farm workers in the fields, these are farm workers from up and down the state. I ask that you hear them and listen to their concerns. These bills are an effort to put their concerns into some changes that recognizes the areas that they think need to be improved. In many ways, this may fly in the face of conventional wisdom and points of view, but they are honestly and legitimately held by the individuals you'll be hearing from for the reasons and the purposes that are before you today. We have farm workers here from Kerman, Reedley, Delano, Richgrove, Visalia, Salinas, over 100. Not all will line up. Some have to go back home. But they are representative of a very different point of view and a very different reality there. And I'm asking, as we present the bills, for the courtesy of your attention to these individuals. This is important for them to be heard, and I appreciate the opportunity to present.
I would say that I know that everyone will be heard today. This committee welcomes all perspectives.
I understand that.
And we may not all agree, but at the end of the day, this committee cares about helping working people. Everyone will be heard. Everyone is welcome. With that, would you like to begin with AB 3092?
Yes.
Please proceed.
And again, the premise was not to suggest that that's not the case, but we are in an area that is a bit unusual with respect to what farm workers and their points of view and their needs out there. And with that, we'll introduce the bills and hear from those who would like to see them moved forward. California law establishes the right of agricultural employees to form, join, or assist labor organizations in collective bargaining activities with agricultural employers regarding wages, work conditions, or other aspects of employment. However, current law governing agricultural relations is silent on instances when a labor organization wins an election for the right to represent a group of workers, but then, in the opinion of these farm workers, disappears. AB 3092 requires the ALRB to nullify a union contract if the union abandons the workers for a period of 3 or more years. In my district and in other parts of California, there are groups of workers who have been abandoned by the unions that they voted for, in some cases more than 20 years ago. The workers there today were not part of the decision-making, not part of the vote, were not even employed at the time, and they respectfully request that the union earn the right to represent them, not simply have a contract forced upon them and wages that they had nothing to say or have input in with respect to their paychecks. So this bill would offer protections against this practice. This bill would make it so that any agricultural labor organization that abandons for longer than 3 years the workers it was elected to serve would then lose its certification and right to represent the bargaining unit. Here to testify in support of the bill and explain the need for the bill is Sylvia Lopez and Jesse Rojas.
Thank you.
Hi. Yeah. My name is Sylvia Lopez, and I'm a farm worker from Fresno County. Me and my whole family, we works at the field since we came to United States for a dream that my dad said that here United States will respect us like they couldn't do it in Mexico. So that's why I'm here today. I thank you guys to be here, and I believe it's a hard position too to be there and listen to a lot of things that is going out there. I'm here and I support this bill because we be suffering in this area in Fresno County since 2012. Sometimes I think that this never gonna end, but then I look at to north here in Sacramento and I think the capital is for something. I think it's there because maybe it's a hope that one day they will listen to us and help us and to be heard. I was witness that a lot of things happen to us. We are more than 3,000 farm workers in this area, Fresno area, that we've been suffering because we haven't been heard. And today I came here with a lot of hope, and in a moment I feel that I'm just wasting my time. But then I think, and then I remember those 3,000, more than 3,000 farm workers out there, their kids, their families, and that's why it gives me strength to be here in front of you guys. And assuming that you guys are here for us, farm workers, immigrants, Mexican, Hispanic, and that gives me hope again to be here in front of you guys today. I've been here before, and I support this law because the United Farm Workers, they abandoned these workers more than 20 years, and I think that's just not right. And one of my parents' dreams is that they told us that we are going to be respected like a human in this country. And that's one of the reasons that I'm here today.
Thank you. Next witness.
Thank you. Jesse Rojas, spokesperson for Pick Justice, the voice of the 99% of farm workers in the state. So AB 3092. Thousands of employees at a large peach farm in Fresno County for many years now had been earning the highest industry wages. In fact, some of them earn more than a school teacher. When suddenly this union that disappeared for over 20 years back, they come back to force itself on the workers, which most of them were not even born back in the 90s. The union told the workers that they would have to pay part of their money, 3% of their wages, to the union, or they would be fired if they didn't. And then the ALRB created a contract without letting the employees see it, review it, or vote for it to force on these workers. Even though the contract would actually lower their pay. And on top of that, it would strip them of the right to protest, which I think is a civil right, fundamental right in this country. The ALRB even admitted themselves that the union had disappeared because they had no way to prove that they've ever sent a fax, a telegram, or even smoke signals during those 20 years. But the ALRB said the law didn't allow them to recognize abandonment. That's pretty disturbing. It's like imagining SEIU abandoning the hundreds of workers in this Capitol, in this building, never ratifying a contract, never negotiating on the table. Imagine the chaos there. Well, that's happened to farm workers across the state. So for the sakes of thousands of real farm workers, the 99% immigrant Latino farm workers that came to this country escaping Mexico, like myself, let the ALRB decertify unions that disappear, that do not represent workers. So I urge you to vote yes on this bill.
Thank you. Others wishing to add on in support of the bill?
Hello, my name is Alejandro Altamirano. I'm 22 years old. I live in Madera, California, and I support this bill because I'm a single, I'm not a single parent, but I don't have parents here, and I have a wife and kids, and those 3% that they're taking away from us could have been for my kids, which I don't have right now. I don't have that 3%. I didn't see no contract, anything like that. So I think it would be fair if they would at least let us know or advise us. I have bills to pay. I have 2 kids, and it's really hard. I don't have somebody to fall back on. I don't have parents, so that 3% will help me out a lot. That's it. Thank you.
Mr. Chairman, and I appreciate, I do understand the process and the rules here, and a reminder who they are and that they support the bill is certainly sufficient. If you allow them to continue to testify, that would be fine, but we would certainly recognize the rules of committee.
We do have a rule that name, affiliation, and position. How many speakers do you have, sir?
About 20. It's about 20.
Probably 20. 20.
I will. Hi, my name is Roselda Lopez. I come from Madera, California, and I support AB 3092.
Thank you.
Hello, my name is Lucero Lopez. I come from Madera, and I support AB 302.
Thank you.
3092.
Thank you.
Hola, buenas tardes. Me llamo Margarita. Yo soy trabajadora del campo y yo estoy con estas 3 leyes y quiero que se me respete, mis votos. Quiero que cuenten mis votos y pues es todo. Gracias.
Gracias. Thank you.
Hello, my name is Angel Lopez. I'm in support AB 3092.
Thank you.
Hi, my name is Angel Rincon. I am support in person the AB 3092.
Thank you.
Soy Angelina Pérez, soporto la ley AB 3092. Gracias.
Gracias. Anyone else wishing to add on in support?
Mi nombre es Edith Ruiz y trabajo en el campo y también apoyo la ley que no recuerdo el nombre, pero la de Patterson, la que él está apoyando para beneficio de los campesinos.
Gracias.
Sí, mi nombre es Claudia Barrera y apoyo la ley AB 3092.
Gracias.
Mi nombre es Gerardo Ramírez y estoy con la ley AB 32.
Gracias.
My name is Fernando, and I'm here to support the AB 3092.
Thank you. Anyone else wishing to add on in support? Seeing none, is there any opposition? Please come forward.
Good afternoon, Mr. Chair, members of the committee. My name is Mario Martinez on behalf of the United Farm Workers in opposition to AB 3092. I did want to correct some serious misinformation and frankly dishonesty about the state of the law. The author told everyone here today that the law is silent on this issue. That is false. That is false. The law is not silent. For almost 4 decades, various members of the Agricultural Labor Relations Board, going back almost 40 years, have rejected the quote-unquote abandonment defense because it would permit employers to refuse to bargain with the union selected by their employees. That law has been not only approved by the courts of appeal, but recently, in a unanimous decision, the 7 members of the California Supreme Court supported that interpretation of the law. So for the author to say that the law is silent is false. It's false. This idea of abandonment has been rejected precisely because employers refuse to bargain with unions that are represented by employees. The law is very clear. The California Supreme Court has approved this interpretation. There is no need to try to change that law because the Labor Board has the expertise. The justices have looked at this issue and have rejected it. with respect to the issue of workers not having voted, that's the state of the law with any labor law. The auto workers that voted for union representation decades ago don't have to re-vote every year to have representation. The California teachers that are represented by their unions do not have to vote every year, even though those elections took place decades ago. That's the same principle here. The California Supreme Court recognizes that when employees legitimately want to do away with their union, not because their employers forcing them to or supporting them to, when employees legitimately want to do away with their union, there are procedures there in place for those employees to use to vote out their union. Based on that, the union opposes AB 3092. Thank you.
Thank you. Additional opposition?
Mr. Chair and members, Mark Schacht with California Rural Legal Assistance Foundation in opposition.
Thank you.
Mr. Chair, members, Michael Young with the California Labor Federation, also opposed.
Thank you.
Jessica Stender, Equal Rights Advocates, opposed.
Thank you.
Shane Gussman on behalf of the Teamsters, opposed.
Thank you. Anyone else wishing to speak in opposition? Seeing none, we'll turn to members of the committee for questions or comments.
Mr. Chairman, may I close?
We were just going to have questions from the committee members, and then you would have an opportunity.
Then to close?
You'd have an opportunity
Fine.
to close. Absolutely. Assembly Member Gonzalez-Fletcher.
Mr. Patterson, can you define abandonment?
Yes, I can. Actually, with the ALRB's own definition of abandonment, and I'm quoting, a showing that the union was unwilling or unable to represent the bargaining unit.
And the ALRB then agrees with you that these workers were abandoned?
No, what I'm saying is...
So you're giving me a definition from the ALRB.
Yes.
The ALRB has rejected in this claim and brought forward workers. God bless those workers. I want to thank you for coming up and using your time, which I'm sure is uncompensated, to come talk to us, because I do value farm workers. I value farm workers so much that I consistently vote for their wages and benefits to increase. This is not a benefit that this bill would do for you. But I want to be clear. Any suggestion that we would change the law in order to encourage growers or any other employer to not, in an honest way, bargain with a union that has been chosen by workers is incredulous. The thought that we'd even bring something like that forward to encourage what is already standard practice throughout private employment to not bargain that first contract is insulting. And then to somehow suggest that it's abandonment by the very people who work so hard with those workers to organize them into a union to have a voice. I am so sorry that your employer has so misled you on this issue. That is really disheartening. No, I am not asking. I am telling you. I am sorry for that. But it is insulting to me, as somebody who has spent a lot of my life working for farm workers, to suggest somehow that this helps farm workers. It helps an employer not have to recognize the will of the workers. I won't be voting for this bill today.
Thank you. Other questions or comments from committee members?
I'm curious to what Mr. Rojas has.
Thank you. And it's not really a back and forth. It was just clarification for the record. Yes, the ALRB has admitted it multiple times, and I would be more than happy to submit it to your office, Mrs. Gonzalez, that they've admitted to the abandonment. In fact, you just had the Mario Martinez. Did he show you any facts or any single record that they did not abandon for that fact? No, they never disputed that in the 5th District Court of Appeals. They never disputed it in the Supreme Court. The ALRB, they never disputed it to the ALRB, and they've also never proven that there was one single communication in those 20 years. So in regards to abandonment, yes, they were abandoned. They don't even refute that.
There was no attempt to ever bargain a first contract.
Correct.
I don't think that's true.
You have the attorney sitting here right now.
And I know that this is an ongoing case, and the ALRB has ruled, in fact.
Well, the abandonment is not an ongoing case because there's
stepping
no...
in here, We're going to have robust discussion.
Yes.
We're going to disagree.
And let me just...
But we're going to do it in a manner that is
Yes,
appropriate.
and I appreciate that. Again, ALRB has a definition showing that the union was unwilling or unable to represent the bargaining unit. And there are factors that they take under consideration. If a union simply ceases to communicate with the workers or employers, makes no attempt to advocate on behalf of the workers for numerous years, how does this activity not qualify as abandonment under the ALRB's definition? And that has been the experience that these farm workers have had. And with that, they have asked that abandonment be something that we consider in this bill, and that's what we've done.
Suffice it to say, there is not agreement as it relates to the issues of abandonment, but we appreciate and hear your points. We hear the points of the members of the committee. Assemblymember Mathis, did you have additional question or comment?
Just I appreciate Big Justice making the time to make it up here and taking the trip out of the field. Mr. Chairman, I motion to move the bill.
There's a motion. There's a motion and a second. Additional discussion, question, or comments from members of the committee? Seeing none. Sir, would you like to close?
Nothing in this bill prevents a union from filing unfair labor practice charges for an employer failing to negotiate. However, if instead of negotiating, a union does in fact disappear for a long period of time, not only fails to file an unfair labor practice charge, which has been going on in this case, but also does not take access to into the fields to check on the employees that elected it, does not file grievances, does not call the employer, nor send any letters or emails. These are acts of abandonment by any definition. And of course, nothing in the bill says that the union cannot try to win back those employees in another election. What this bill does do is to protect those workers whose unions have abandoned them for 3 or more years, as defined in the very language of the ALRB that I cited and the specified failures in many cases of showing up and doing the responsibility that they were elected to do 20-odd years ago. So at some point, the representative capacity in an abandonment is lost when the bargaining unit has chosen not to represent for whatever reason. So in these rare cases, and we're admitting these are rare, but they do exist, the law should allow the ALRB to determine that abandonment has occurred and decertify the bargaining unit. With that, I ask for your support.
Thank you. We have a motion and a second. Madam Secretary, please call the roll.
Motion is due pass to appropriations. Thurman?
No.
Thurman, no. Flora? Aye. Flora, aye. Gonzalez-Fletcher? No. Gonzalez-Fletcher, no. Jones-Sawyer? No. Jones-Sawyer, no. Calra? No. Calra, no. McCarty? Mathis? Aye. Mathis, aye.
That bill fails, sir.
Thank you.
Thank you.
Next to AB 3093, we are suggesting a title here, the right to an equal engagement. The right to choose our own representatives is a bedrock principle of our constitutional democracy. That principle applies to all Californians, including those who work in the fields. Under current law, when an employer and a union fail to reach a collective bargaining agreement, the ALRB can create and enforce a collective bargaining agreement through the process of mandatory mediation. Mandatory mediation is different than a collective bargaining agreement because there is no mutual agreement between the parties, and it does not allow the workers themselves to be a part of the discussion. This bill will give farm workers the legal tools they need to have a say in determining the terms of their own labor contract if those terms in that contract are a product of the mandatory mediation and conciliation. Once the ALRB sets forth the terms under mandatory mediation, the two parties must abide by them, the union and the employer. But what about the farm workers? The process allows for an unelected board to create and enforce provisions of a contract that farm workers had no say in creating. What this bill does is change this and give farm workers the right to vote on a contract created by the board before the contract becomes binding. With this bill, the result of mandatory mediation and conciliation will no longer be forced on farm workers without them having a chance to approve the agreement with a majority vote. The ability to ratify or approve a labor contract is shared by overwhelming union workers in California, yet in this particular process, they are being denied to farm workers. And again, Sylvia Lopez and Jesse Rojas are here to testify.
Thank you. We welcome your first witness.
My name is Sylvia Lopez. I support this AB 3093 because I was living this in 2012. The ALRB and the company, they were negotiated without us, the worker, without asking us if we want to see the contract. Just to make this very clear, I'm not against the union, but I just didn't like the way they were doing it. We went to Modesto, California to try to get in this negotiation and with the LRB, and they didn't let us to see what is the contract have. So I think that's something that that is not right. And I think we should have the same right. We don't have to wear a red T-shirt to have the right and to be respected and to know what is inside the package that we're going to be buying. Because actually we're buying. We're going to pay from our check every week to be join a red T-shirt. And since we're okay in this company, we don't need a red T-shirt and we don't need to pay our 3%. And we think that we deserve to know what is in the package. That's all.
Thank you. Next witness.
Thank you. Jesse Rojas again with Pick Justice, AB 3093. As I said previously, the contract the LRB wanted to force on thousands of the industry's highest paid employees and workers would have actually lower their take-home pay because, it would include 3% of their gross wages, including vacation pay. That's not to include potential fines, assessments, work permits, initiation fees, and reinstatement fees, et cetera, et cetera. Not only that, but the contract would have prohibited the workers from a fundamental right, which is to protest and demonstrate. Fundamental right in this country. It would have actually prohibited them from demonstrating this ALRB written contract. Now, it's wrong to force a contract on workers without letting them choose. We had a gentleman that mentioned United Auto Workers. Well, they have the ability to see the contract, even as a committee of workers, but they have the ability to see and vote on it. They were not abandoned. So let's not use examples that do not correlate to this particular example. I understand the previous bill. I actually get it. But AB 3093, all it would give is workers the same rights that every other classification and industry of workers in the state and the country have to vote on the contract if they like it or not. We support collective bargaining, right? Well, collective bargaining should be transparent. And I'll close with this. I would ask myself, and I would think about this. If this union and labor organization did not abandon the employees for over 20 years, and in another case for over 40 years, why hasn't there been a contract? Why haven't they collected 3% wages for the last 20 years? Thank you, and I urge you to vote yes on this bill.
Thank you, and I'm certain that those who are opposed to the bill, when they have their opportunity, will address some of the questions that you've raised. Others wishing to add on in support of the bill? Anyone wishing to add on in support, please come forward.
My name is Gerardo Echeverria, and as a former farm worker, I support this bill.
Thank you.
My name is Lucero Lopez, and I strongly support this bill.
Thank you.
Hi, my name is Angel Rincon. I support the 3093.
Thank you.
Gerardo Ramírez, estoy con la 3093.
Gracias.
Hi, I'm Rosilda Lopez, and I support AB 3083. Thank you.
Thank you.
Hello, I'm Angel Lopez and support 3093.
Thank you.
Mi nombre es Edith y apoyo la ley.
Thank you. Gracias.
My My name is Fernando, and I support IB 3093. Thank you.
My name is Alejandro Altamirano, and I support this bill.
Thank you.
Mi nombre es Angelina, soporto la ley AB 3093. Gracias.
Gracias.
Buenas tardes, mi nombre es Margarita Ramírez y apoyo este bill.
Gracias.
Sí, mi nombre es Claudia Barrera y apoyo este bill.
Gracias.
Mi nombre es Estela Marín y apoyo esta ley. Muchas gracias.
Gracias.
Mi nombre es Roberto Ángeles y apoyo esta ley.
Gracias.
Mi nombre es Rosa Casillas y apoyo AB.
Gracias. Anyone else wishing to add on in support? Seeing none, is there any opposition? Please come forward. Please proceed.
Good afternoon again, Mario Martinez on behalf of the United Farm Workers in opposition to AB 3093. I did want to once again correct a few misstatements. Farm workers do have a say in what is negotiated, and that's through a democratically elected negotiating committee that at least the United Farm Workers and I know other unions use. It's a committee composed of workers who inform their representative what kind of issues they want addressed at collective bargaining. So the idea that farm workers have no idea what is being negotiated is simply false. The idea that farm workers at this particular company, Garawan Farms, did not know what was negotiated is also false. The farm workers know very well. Copies of the proposed mediated agreement have been distributed to the workers, so they know exactly what's in the contract, what was negotiated. The idea that this mediated agreement lowered pay is simply false. The mediated agreement called for wage increases above and beyond any 3%. One of Garawan Farms' complaints is that it was being asked to pay too much over and above beyond the 3% in order to give workers increased wages. Again, those things are also false. There is no legal right to ratify a contract. That's something that's discussed among the unions. It's an internal procedure that's sometimes afforded to members, sometimes it's afforded to committees. What the law says is that the unions have a right to determine how to do that within their own constitution. Now, again, with respect to this specific employer, the idea that it was paying the highest wages in the industry is laughable because it is being sued for minimum wage violations and has not paid the highest wages in the industry because of these minimum wage violations. So once again, there is no need, there is no right, legal right, for what is being asked for here. It's another way for the employer to interfere with the democratic process. This employer was already found to have interfered with the right of these employees to select or not select a union. A second vote would add an added hurdle at getting a collective bargaining agreement that the binding mediation law was designed to protect. So for those reasons, the union is in opposition of AB 3093. Thank you.
Thank you. Additional opposition?
Mr. Chair, members, Michael Young with the California Labor Federation. I would also add that the ALRA would only take this action when the employer is engaged in unfair labor practices at the work site. This is something that the ARLW does when the employers fail to bargain in good faith, when they've done such bad damage during the negotiating process that's extended over a year that it's almost impossible for those workers to get a fair collective bargaining agreement. So with that, we're opposed. Thank you.
Thank you.
Jessica Stender, Equal Rights Advocates, we're opposed.
Thank you.
Mr. Chair and members, Matt Broad on behalf of the Teamsters in opposition. Thank you.
Thank you.
Mark Schacht on behalf of California Rural Legal Assistance, also in opposition.
Thank you. To the members of the committee, questions or comments? Assembly Member Mathis.
I've actually got questions for the UFW guy. If he could come back up. Attorney.
Mario Martinez for UFW.
There we go, Mario Martinez. Mr. Martinez, in your comments, you stated that they're already doing these things, they're already meeting, and granted, I'm subbing today on labor, so this is my first time here, so forgive me. I'm usually on other committees, but I've ran several organizations in my life and things of that nature. How often do these groups? So walk me through this. So they come through, they contract, they take a vote. Now your union's in charge of the employees, correct?
The union acts as a representative.
So the union acts
for purposes of collective bargaining.
Okay, so how often do they meet? Is it a monthly thing? Is it a quarterly? Is it biannually?
It depends on whether there's an existing contract or whether they're trying to negotiate a new contract. If there's a contract in place, then there's less need for meetings. If they're trying to, in this case, of Garawan Farms, I believe the union from the beginning of 2013 into the end of 2013.
So is there a standard contract that you guys use, or?
I'm trying to answer your question. Met about 11 times, and then they had another 5 or so meetings with the mediator to try to come to an agreement.
I'm not asking about the Grimway case. I'm asking. I mean, you're an attorney for the union. I mean, what's the standard that you guys put together? I mean, I'm trying to picture this in my head so I can explain this to folks back home, because I mean, most organizations either meet monthly or quarterly. And then, how do you disseminate the information back down to the people that it's representing? I've sat on national boards, I've sat on state boards. How do you guys send this information back down?
The union meets as many times as is necessary.
Meets with who?
With the employer. They will have a worker negotiating committee that is composed of democratically elected worker leaders. And then based on the meetings they have with the employer, they will then have meetings with the rest of the workforce to advise them how negotiations are going.
And is there a standard on how often those meetings are to occur?
It depends on how negotiations are going with the employer. If an employer tells the union, we're never going to sign a contract with you, don't bother meeting with us, that may affect.
That's not what I asked.
That may affect how many.
Mr. Mathis, if we would, we let the witness finish
answering your question. That may affect how many times the union meets with the employer. If the employer refuses to meet, that will affect how many times the union meets with the employer. So it depends on the response
I'm concerned
of the
with
employer.
how often the union meets with the people that it represents on the ground.
During active negotiations.
Is there a standard within your union on that?
During active negotiations, very frequently. It will be on a weekly or biweekly basis. There's nothing written in the union's constitution, but when there are active negotiations and there's a responsive employer, it will be very frequent.
So the UFW doesn't have within its constitution an annual meeting time for talking to members of the union?
No, and I don't know that any union has that in its constitution.
Okay, I've worked with other organizations across the U.S. and they all have meeting requirements and when they meet and how they meet and all those things written out in their constitution. So I'm curious on how this works. So, all right, that's it. Thank you.
Thank you.
I think that the witness established a few times that the frequency of meetings increases when there's negotiating going on.
Mr. Chairman, I'm new to this, and I'm just trying to figure out how this works because I've seen other organizations. So I'm just curious. The constitutions and bylaws usually have standard meeting times,
but it would not be unusual. And we want you to come back and have an understanding about how organizations typically work. Labor organizations have at their heart to represent those that they represent in contract negotiations and to advocate for them. It would not be unusual for them to not have some permanently articulated schedule for when they meet, because their meetings are often dictated by any matters that they might be dealing with at the time as a witness.
Oh, absolutely. I just find it surprising that there's not a standard meeting time written into their bylaws or their constitution.
It's noted. Thank you. Anyone else? Any other questions from members of the committee? Comments or questions from members of the committee? Bill has a motion and a second. Any other questions or comments? Seeing none, Mr. Patterson, would you like to close?
I think we strayed just a little bit from the focus, and I want to bring us back to mandatory mediation and conciliation. It is in that context that this bill attempts to be able to put the farm workers in the room. And I went through all of this with these farm workers back in the times when we were going through the mandatory mediation. And I was surprised that they were not allowed in the room, that they could not have representatives in the room. This was something that the ALRB board did just amongst themselves. And these are the individuals who have the largest stake in the decisions that were being made inside that room. And then also was a big surprise to me that when the ALRB determined what they were going to require in the contract and mandatorily present it to the farm workers, the very people that are going to have to live with those details, they don't have an opportunity to look at it, study it, and then they don't have an opportunity to vote on it. That seems to me to be a real departure from, I think, general practice, and certainly I think it does call into some question whether or not these farm workers really are engaged and have the opportunity to sit, listen, hear, and vote on what's going to affect their lives. If other unions and union members have the right to see the contract, they weren't even allowed a committee in the room. So it was a de facto mandatory without seeing it, understanding it, or even having the opportunity to vote on it. I really think that contracts should never be forced on workers. If a contract really is in the workers' best interest, let them vote on it. Let them see it. Let them be in the room. Let them have at least a committee in the mandatory meeting. It's normal for contracts to be ratified by a vote, especially since it's the workers who are going to have to live with it. And I just think that if this is an important right or privilege that most union members have in the state of California, these farm workers should have that right and privilege. And again, this is with respect to only that area of the mandatory contract that they are forced to accept, whether they like it or not, or whether they can vote on it, yes or no. For those reasons, I think this bill narrowly scopes this particular, I think, blemish in the due process and the operational practices of ALRB, and that's what we're attempting to fix here. And with that, I request an aye vote.
Thank you, Mr. Patterson. We note the comments that you've made about forced decisions and things of the like. We also note that we heard from representatives today who have said that there are representative groups that work on behalf of the workers, and that is the way in which information about the contracts are communicated. But thank you for your close. Please call the roll.
Motion is due pass to appropriations. Thurman?
No.
Thurman, no. Flora? Aye. Flora, aye. Gonzalez Fletcher? Gonzalez Fletcher, no. Jones Sawyer? Jones Sawyer, no. Calra? No. Calra, no. McCarty? Mathis? Aye. Mathis, aye.
That bill fails. Moving on to AB 3094, please.
And in presenting the final bill, I do want to thank you for the courtesy and the opportunity of presenting and for listening, hearing these farm workers with their point of view on something that obviously is sort of out of the mainstream of accepted understanding of what is actually happening in the fields. But these are real people living through these significant circumstances, and they have asked for me to present these on their behalf because they have gone through these things and has really created some real heartache. This final bill is really a due process bill. Seeks to protect rights of farm workers. The ALRB is currently authorized to throw out the results of an election and certify a labor organization as the exclusive collective bargaining unit if employer misconduct is found that may have interfered with the vote. However, there is no recourse if misconduct by an entity other than an employer is suspected, nor is it an option to have a new election if this were to occur. So, in fact, there is not even a judicial review available within the appellate court system when the ALRB decides to void the results of an election. And we need to remind this committee that thousands of these farm workers have already voted, and those votes are sequestered. They're in a box someplace, and they've just disappeared, and they're not being counted. So the right to choose employee representation is really critical to farm workers, as it is to all workers, because of the impact on wages and working conditions and benefits. So this bill provides protection to ensure that the voices of these workers are in fact heard. And again, this is with specific reference to the mandatory nature of the ALRB activity. So under the bill, the ALRB must order a new election to be held in the case of misconduct by an employer, a board personnel, or a labor organization. This gives the power to decide back to the employees. This bill would also, subject to review by an appellate court, a board action that certifies the result of an election without counting the ballots of workers. And that is the precise situation we see in Central California. And here again to testify in support is Sylvia Lopez and Jesse Rojas.
Hi, my name is Sylvia Lopez, and I support this Bill AB 3094 because, honestly, I repeat this again once more time. More of 90% of farm workers in Fresno County, we voted in 2012, and the agency, the state government agencies, local, they kidnap our votes, and they haven't been counted since 5 years ago. And this year is going to be 5 years that we voted, and they didn't want to count our votes. And just going to make this comment. What is that? Why they too afraid to count our votes? If everything's lie, like they said, why they so afraid to count our votes? Why they don't count the votes and let the vote decide what's the farm workers what they want? Because I respect you guys, one of each of you guys, like a human being, because you guys are human being, and I want to respect people. But I would like also invite you guys to go and talk to this more than 3,000 farm workers so you guys can see what is the real thing, what's going on really over there, because maybe I can come and I can say lies, or other organization, they can come and say other story, but the real story is out there. It's just to grab some boots and some jeans and talk to us. We are more than 3,000 out there, and we would like to see you guys there so you guys can make a fair decision in this situation, because this is serious. This is very serious, because we're talking about kids, our families, their college, their books, the expensive, everything. So I think I suggest that, and I support this bill strongly, and thank you guys for your time.
Thank you. Next witness.
Thank you. Jesse Rojas with Big Justice. So finally, AB 3094. I think this was most important for farm workers especially. They need to be allowed to choose their representation, obviously. Thousands of workers achieved the vote. As we mentioned, we keep going after this sample in Fresno area. The vast majority of them twice completed petitions or signatures for that vote. The ALRB administered the election. The ALRB allowed the election, but now they want to destroy the workers' ballots. I mean, you had Sylvia Torres-Guillen, the former general counsel of the ALRB, literally say in court, supporting or suggesting to the court the destruction of the ballots. I mean, this is America. Who wants to destroy votes? That is completely wrong. Is it because they're just farm workers? No. Just immigrants? Just Latino immigrants? No, it shouldn't be that. Everyone should have the right to vote and the right to see the results of that vote. Like any general election. If the LRB has a problem with an election they ran and they administer and they put the rules to, then don't punish the workers. Just do another election. If something's so good, if a labor organization is such so-called contracts so good, what is there to fear? Why transparency and accountability is such a a fear here if it's so good. They'll vote. They said they'll vote as many times as you want every single year. They keep saying it. And I want to say it's insulting to say to me, at least, and for them, they're not paid to come here. They leave their kids behind. This is not the first time they've done this dozens of times. You guys know that. And to say that it's just driven by a particular thousands of workers at a particular location, that's absolutely false. We don't have time here to get in a debate, and I want to be respectful of everyone's time. But I would encourage anyone who would like to actually visit at a park or wherever you want, workers from around the state, Salinas, Monterey, Santa Maria, El Centro, Bakersfield, Delano, Fresno, I mean, you name the place. And you actually want to talk to them directly and ask them questions directly and have them show you their pay stub so you see they're a real worker, I would be more than happy to put that out there. Because this is just a few of them. And they all have a lot of problems with their rights. And let me tell you, growers, this is not grower-oriented. This is pro-employee, pro-Latino, pro-immigrant, pro-workforce. They're the ones scrambling around to come up with gas money. They're the ones losing thousands of jobs. Not the growers. The growers are set for life. They have other interests. This is pro-employee, period. So I urge you to let a real court see all these issues. And I would like to close with this. Before the gentleman from Bakersfield, the attorney, comes up to speak and distort the facts, which I don't find credible, an attorney that allowed his own client to be sued in a class action lawsuit for almost $2 million for breaking labor law. But with that being said, I encourage all of you to actually look into the facts. He failed to mention that the abandonment, or the MMC process was actually being litigated in the 5th District Court of Appeals because an employee who showed up to Modesto was not allowed to go in and see the contract.
Thank you.
So, thank you, and I urge you to vote yes.
Thank you. Others wishing to add on in support to this bill?
Move the bill.
Second. Bill has a motion and a second. Others wishing to add on in support?
Yeah. My name is Gerardo Echeverria, and I support this bill.
Thank you.
My name is Lucero Lopez, and I support this bill.
Thank you.
My name is Angel Rincon. I support 3094.
Thank you.
Buenas tardes. Mi nombre es Margarita Ramírez. Yo apoyo la ley de AB 3094.
Gracias.
Roselda Lopez, I support AB 3094.
Thank you.
Buenas tardes. Mi nombre es Estela Marín y yo apoyo la ley. Gracias.
Gracias.
Sí, mi nombre es Claudia Barrera y yo apoyo la ley 3094.
Gracias.
Mi nombre es Rosa Casillas, vivo en Madera, California, apoyo a AB 3094.
Gracias.
Mi nombre es Edith, vengo de Salinas, trabajo bajo contrato de unión UFW y please help, I need help, please.
Thank you.
Hello, my name is Angel Lopez. I support AB 3094.
Thank you.
Mi nombre es Angelina, apoyo la ley AB 3094. Gracias.
Gracias.
My name is Fernando, and just want you guys to count our votes. That's all I'm asking.
Thank you.
Gerardo Ramírez, con la 3094.
Gracias.
Mi nombre es Roberto Ángeles y apoyo la ley de Jim Packerson.
Gracias.
My name is Alejandro Altamirano. I support this bill. I really hope you guys listen to our voice and understand us. That's all. Thank you.
Thank you. Anyone else wishing to add on? Seeing none, is there opposition to AB 3094? Please come forward. Please proceed.
Mario Martinez on behalf of the United Farm Workers in opposition to AB 3094. The language of the proposed bill talks about the remedies that could be ordered in cases where an employer interferes with an election process or a union interferes with an election process. The bill is unnecessary because those standards are well laid out under current case law. If the committee is interested in detail of how this works, the Labor Board's recent decision in 42 ALRB number 1 details the extensive illegal actions of Garawan farming, how they improperly interfered with the election, and how they invalidated the election. That particular decision is actually being reviewed by a court of appeals, as is proper. So the idea that there's no review of the board's decision is incorrect. There are procedures for when employers interfere with elections. There are remedies for that under well-established labor law. There really is no need for the bill. If there's any questions, I'm happy to answer, but UFW opposes AB 3094. Thank you.
Thank you. Others wishing to add on in opposition?
Michael Young with the California Labor Federation. We're also opposed.
Thank you.
Jessica Stender, Equal Rights Advocates, very much support the rights of farm workers, but don't believe this bill accomplishes that. Apoyamos mucho sus derechos como trabajadores, pero no pensamos que este proyecto de ley acumple eso. We're opposed to this bill.
Thank you.
Mark Shaw, California Rural Legal Assistance Foundation, in opposition.
Thank you.
Shane Gussman on behalf of the Teamsters, opposed.
Thank you. Anyone else wishing to add on in opposition? Seeing none, I'll turn to the members of the committee for questions or comments. Assemblymember Gonzalez-Fletcher.
This has been heartbreaking to sit through this because I think those of us who have looked at the entire process of what Gerwin has done, they literally fired workers in order to avoid or try to avoid a union election. And yeah, that might have been, a number of years ago. But the fact is, if we don't account for that, if we don't allow our board to account for every bad act that the employer has done and every insistence that they refused to allow a union, they were poor actors, and in the process, people lost their job. They're poor actors in ever wanting to negotiate a contract. They created all the situations that we're now here talking about. And that's heartbreaking because I understand self-determination of workers and wanting that, and workers deserve that. But we can't also, and one day, hopefully, this will be resolved, but we can't allow bad actors. It is about the growers. We can't allow bad actors to violate the law over and over and over again to keep workers from being able to have their rights. And that's what happened here. It's clearly what happened. And it's hard because, of course, it's hard to sit here and listen to an author promote farm workers when that author's never voted for anything that would extend the benefits and wages of farm workers. This is a proxy fight, and one that doesn't even make sense. And it hurts me because I want to do everything I can to help all of these workers. You've been lied to. And it's great. We can say this is worker driven, and sure, but the ads that are coming up on my Facebook are not being paid for by workers. The shirt you're wearing, that's not being paid for by workers. This entire group, are you telling me this entire group and the lawsuits and everything that's been played is by the workers? No, it's by the employer. And our labor laws are fully out of balance. And they always, always, in every instance, benefit the employer over the employee and the right to unionize. So I understand the frustration. And as somebody who has dedicated my life to representing workers, I empathize the frustration. But this was absolutely caused. Every situation we're in now was caused by the employer. And the only way we have rules that will ever benefit workers is if we hold those employers accountable for their bad acts. So I'm sorry, I can't support it. I'd meet with the workers anytime you ask. I will come down and talk to the workers as I've continued to. Throughout any process, anytime a worker has asked me to meet with them or come see them. But I hope you understand.
I understand, and I'm going to be waiting for you.
Yes, but I hope you understand that your employer caused this situation. The people lost their jobs because they supported the union.
I'm
That's
sorry.
where this all started.
Excuse
That
me.
has been litigated.
Just a moment,
and proved.
please.
So,
Just a moment, please. Please allow the member to finish.
so I just want to state that because it is very difficult for somebody who advocates on behalf of farm workers and has a clear record of that, not just coming forward when an employer or grower supports a bill. It's heartbreaking because I think, unfortunately, that you have been led down the wrong road.
If we're going to maintain decorum and not have a debate here, if any member of this committee wishes to ask a question to the author or to the witness, now would be the time to do so.
I'll give you a chance to have your last words. But let's, we do have a long night.
I
We got
don't
a
know.
lot going
I
on,
don't
so I
know.
respect.
I don't know if I can make a question.
Just make a
Can
statement,
I?
make it quick.
So that means that we're going to be forced to be in a contract with a union? If it's, you say that it's the employer fault, do you think that's going to keep us to join or to make a contract with the
Let me
union?
ask
I
you-
don't know.
let me- let
I
me
don't,
ask
I don't
you this question.
understand.
Let me ask you this question. Earlier today, the attorney for the UFW said that if the members don't want to be represented by the union, that there are steps that they can take to have that changed. Have you all taken any of those steps?
Yes.
Please elaborate what steps. What steps have you all taken?
If we don't want to join the union, that's why we went to the LRB to ask for an election.
But if you don't, it's not that you don't want to join a union. If you don't want to have a union, that there are certain
I don't need a union.
understood.
Yes.
But there are certain processes that have to be followed. If the union exists, there are many cases where there might be individuals who just say that's not for me and they don't want to. But in order for the union to no longer exist, there are steps that have to be followed to remove the union from representing the workers. And I'm asking if you all have taken those steps to remove the union from
Yes.
representation. Not just going to the ARB to say you don't want it, but what steps have you taken?
An election. We had an election 2013 to decertify that union that we never asked for, that we didn't know that. In a way, I think the company has a responsibility to notify us too that there was a union that was certified in 1990. Most
Did the
of
LRB rule against you in that matter?
Yeah, they said that we collect the signatures, and they said that that signature was a fraud, that we make up that signatures, and that makes us feel so bad.
Understood.
Yeah.
So you had your vote. The ARB ruled against you in that matter. Was there anything else that you wanted to add?
No, just in this, and I just wanted to clarify the process. So they collected signatures twice, and an election actually was approved by the ALRB and ran by the ALRB and administered by the ALRB with no issues. They just locked up those ballots after the day of the election and have not counted it since then. But the whole process was followed by her and the rest of her employees, the appropriate process. Now, one thing if I could add just a quick point. Earlier, Mr. Martinez mentioned the ALRB board. The ALRB board, which is supposed to be a qualified board, is supposed to be a knowledgeable board. Well, let's look at one of the current ALRB board members, Isidore Hall.
I'm going to stop you right there.
No problem. Thank you.
I'm going to ask you to not impugn the members of a board. Their qualifications are not at question here and before this matter. There was a specific bill. If you wish to make another point in advocacy for this bill, I will allow that, sir.
May I?
Mr. Chairman,
I will not allow you to impugn
No
anyone
problem.
in this room or outside of this
Mr.
room.
Chairman.
No
You
problem.
may make your points
No problem.
about the bill.
Yes, sir.
Mr. Chairman,
Yes, sir.
this committee has forced these members to sit through an impugnment of themselves over this bill. There has been issues raised about whether or not they know what they're doing. Sadness over the fact that they're being fooled. And you're outraged by this, and you're not outraged by us being lectured that had nothing to do with the bill.
Sir,
I just asked for us to fairly adjudicate what's happening, and I will help with our witnesses to do that.
I appreciate the witnesses who've been here today. We have listened to everything that every witness has had to offer. There has not been agreement on many issues, including issues around abandonment and issues around the NLRB. I do not think it is accurate for you to say that any member of this committee has impugned any member who's come here to testify. Everyone who's asked for it has been given an opportunity to have their voice heard. We may not have agreement.
I appreciate that. Let me
and at
allow me to
time-
close.
If I may finish. And at times, there may have been emotional and spirited comments raised, but I do not believe it's accurate to say that anyone in this chamber has impugned anyone who's asked for the opportunity to be heard. Today, we have to respectfully disagree.
I understand
and
that.
welcome your close.
I understand that.
Thank you.
This hearing is a matter of public record, and the comments of members who have impugned are a matter of that record, and it's there. I'm going to close with this. The opposition has said that this is unnecessary because there's law, there's penalties for misconduct by all parties. That is not true. Section 1156.3F of the Labor Code identifies only employer misconduct as a cause for ignoring the vote of the workers and certifying the labor organization. There is no other counterpart in that law other than the employer. It seems to me in this country, in this state, that we understand some very fundamental principles of rights that individuals have, that we cherish the concept of legitimate, real representation, that people are allowed freely and openly to choose, and that we also have the ability to seek redress through a judicial system when we have been wronged. Will we honestly refuse to extend those rights to farm workers? Because that's what's at stake here. And that is why these individuals have asked for this kind of solution, because they have been the ones that have been harmed, and the door has been closed to their opportunity to redress a grievance and to have legitimate representation of their own choice. With that, I ask for your vote.
Thank you for your close, sir. Please call the roll. There's a motion and a second.
Motion is due pass to Judiciary Committee. Thurman?
No.
Thurman, no. Flora? Aye. Flora, aye. Gonzalez Fletcher? No. Gonzalez Fletcher, no. Jones Sawyer? No. Jones Sawyer, no. Calra? No. Calra, no. McCarty? Mathis? Aye. Mathis, aye.
That bill fails. Thank you for your presentation.
Thank you for the opportunity of being heard.
Thank you.
We appreciate it.
Next up, we'll be hearing from Assemblymember Aguiar Curry, who's presenting AB 2610. Welcome, Assemblymember Aguiar Curry.